responsible for someone's debts after they die? Hi, I'm Alec Oslin, an attorney at Yanowitz Law Firm, where we've been assisting families with wills, trusts, and probate for over 30 years. I get this question a lot when meeting with the family of a loved one when they pass away. There's these debts. Do we need to pay them? Who's responsible? We keep getting these calls. We're getting harassed. What do we do? Now, the general rule is no. You are not responsible for the debts of a loved one after they've passed away. Now, if there is a surviving spouse, they may be responsible depending on the type of debt that there is. If there is an outstanding medical debt, that spouse may be responsible. Further, if you are also named on the credit card or the financial institution, or if you are on the mortgage with the decedent, you most likely also have the responsibility of paying on that debt. So now we get the question of, okay, so I'm not responsible for paying that debt right now. What happens to that debt? Now, what generally happens is that we have to commence a probate. And a probate is the involvement of the court to probate the will, or if they didn't have a will, we'll look at the laws of intestacy, but we get a personal representative appointed by the court, and that personal representative has the duty to gather all the debts and all of the assets of the decedent to figure out what the next steps are to make everybody whole and get the assets out accordingly. Before any distributions are made, that personal representative will gather all of the debts and they will start paying those debts. Now, there is a priority that is established by statute for which debt gets paid first. So the personal representative will make a payment on all of those debts. All of the creditors, they do need to file a claim into the estate, or they need to notify the personal representative of their claim. After that personal representative has paid all the claims and there are no debts with the decedent, at that point, they would distribute the assets out and we would try to close up probate. But the big takeaway here is that you are not responsible for paying the debts of the decedent just because you may be a brother or sister or a friend. If a probate is not commenced, a creditor can commence probate themselves. So that is a misunderstanding that I see a lot. A lot of times people think, oh, I have to be named in the will for me to bring this probate, or you have to be the surviving spouse, or it has to be a parent. That is incorrect. Any interested party can bring and commence a probate action. So we do have creditors that periodically actually start the process as they're looking to get their bill paid and get the money that is owed to them. What if a probate isn't needed? So if we have a trust-based estate plan, we generally try to avoid the probate process. And a lot of trusts, we generally have language that the trustee is going to pay the claims and expenses and any debts of the decedent. So that is generally addressed in the trust document itself. So the trustee will go ahead and take care of all of those debts. In situations where we don't have a trust and a probate is not needed and the estate is worth under $75,000, we can generally gather the assets via an affidavit of collection of personal property. In that statute, there is a clause that says the assets that are being collected by the beneficiary, that they are going to go ahead and make whole and pay the debts of the decedent. So they are responsible for using those funds that they are collecting to go ahead and pay off all of the debts of the estate. The big takeaway from this topic is please, please, please do not start paying debts of a decedent until you have talked to an attorney, because you may be under no legal obligation to pay those debts. As always, make sure you subscribe to our YouTube channel to find out when we post another video. Thank you and have a great day.